Welcome, everyone. My name is Joanne Epps. I'm the dean at the law school here, and I'm really pleased to welcome you to the second annual Edward Ross Lecture. Mr. Ross, as the brochure says, for those of you who have seen it, died well before his time, before his family and friends were ready. But to honor his life and his memory, his family and friends endowed a lecture series in his name so that we could remember him and the kind of principles that he stood for. Edward Ross was the kind of person that many of us who go to law school want to be, and all of us would want our lawyer to be if we were in need of a lawyer. He was dedicated to his clients, he was kind, he was passionate, and he was a person who put the causes and issues of his clients before himself. I think it's entirely fitting that our second annual lecture is being delivered by Stephen Scheller, someone who also is an unrelenting advocate for justice in this country. Mr. Scheller has had a long career as a lawyer, and I'm really looking forward to his description of many of the highlights of it. I met him 2 years ago and immediately thought this was someone that I liked a lot, he and his wife Sandy, but I also wanted our students and our friends to have the opportunity to know what it's like to hear from someone who's dedicated himself to the underdog. One of the many highlights of Mr. Scheller's career, and I have to tell you they are enormous, following and tracking his accomplishments is no mean feat, and I have to apologize, I can't even begin to do justice to all of the things that you've accomplished in your life. But one of the things was that back in the 60s, when it wasn't so popular to do so, he was appointed to represent the Black Panthers, who were being charged in the aftermath of the Philadelphia race riots. And by connection, he was appointed to follow in the footsteps of Cecil Moore, who many of you know is the person for whom our local street is named, himself a champion of justice in the city of Philadelphia. And Mr. Scheller filled in and in his stead and provided extremely able representation to very needy people at that time. He pursued his career on behalf of whistleblowers, victims of sex crimes. He has now most recently turned his attention to attacking the pharmaceutical industry and the tobacco industry, both of whom I'm sure would rather he devote his attentions elsewhere because his successes against them have been plentiful and numerous and financially satisfying. This has been a person who has pursued a career making sure that the voice of the underdog was heard and that that person's rights were pursued. And so, Mr. Scheller, it's with great honor that I welcome you here today to deliver the second annual Edward Ross Lecture. Thank you so much for honoring us.
Well, I wanted to thank Judge Darnell Jones is here and Judge Sandy Moss and Bob Robner, my good friends. I'm really pleased that you came. Darnell and Sandy, we go back to the times, some of the times I'm talking about, and some of the difficulties. So they were partners in some respects to some of these things. They don't want to admit that, no. Anyway, good afternoon, everybody. I would like to thank Dean Epps and the Ross family, two of whom are here, Edward's wife and sister, yes. For inviting me to speak, and I'm truly pleased that they did that. I consider this an honor, so thank you, thank you. And I would also like to acknowledge Edward Ross, who I never met, but our lives have been intertwined in a way since childhood. Ed and I both grew up at the same time, in the same neighborhood in Crown Heights, Brooklyn. As young boys, we both hung around Ebbets Field watching our beloved Dodgers, and I'm sure we were both extremely depressed when they left. In fact, I would probably be on Paxil at the time if it was around. We even shared, believe it or not, the same favorite restaurant, Katz's Deli in Manhattan. And years later, Ed and I both made our way to Philadelphia to study law. Ed was a student here at Temple, while I was across the river at the University of Pennsylvania. In the end, both of us became successful attorneys, although unfortunately Ed's life was shortened and he was doing great, great things hearings for the public. Tonight our paths have crossed again, as I am the guest lecturer for the Edward J. Ross Memorial Lecture in Litigation, established by Ed's family in honor of his outstanding legal career. Additionally, I wanted to mention a co-counsel of mine in some of the litigation, Mike Mustikoff, who I had the pleasure of working with in the pharmaceutical whistleblower cases. And this room is dedicated by Duane Morris, his law firm, who it's just an interesting coalescing of these events. So, take a breath and then begin, as my assistant tells me. So I'll do that. Gabriel Garcia Marquez's book, Love in the Time of Cholera, is a 1985 Nobel Prize-winning story of love, obsession, and passion, set against the backdrop of cholera. While this may seem to be an unconventional metaphor for tonight's talk, lawyering in the time of saints and evildoers, it begs the question, will you, and I'm referring to the students primarily, as young adults entering the field of law, stay true to your passion in spite of a sickness that pervades our society? I'm talking about the sickness of injustice, discrimination, and greed that weaves itself through the daily life and tempts us with greater glory and for money. Will you, as young attorneys, follow your inner conscience and become the saint, the one who passionately protects our basic rights out of love for our Constitution and law, or allow yourself to become the evildoer or the one who aids and abets those who perpetrate injustice, discrimination, and greed? Injustice, discrimination, and greed are the common thread and are at the very core of each of the cases I will discuss tonight or this afternoon. It was my passion for justice and equality that I actively employed to oppose what I perceived as being wrong, even as I faced an equally passionate adversary who was convinced in the merits of their position. We're going to play several video clips today, and even though these videos are about me and the cases that I've litigated, I want you to think how they relate to you, why you are in law school as students and faculty, and why you're sitting here today. Because the drug company shouldn't have been out there selling the doctor on it, and the doctor maybe should have reconsidered prescribing it and think twice about accepting his lunch and a trip to Florida or wherever.
My malpractice rates are higher than in Delaware, higher than in Wisconsin, higher than in California.
That's because the insurance companies are taking advantage of you.
because the legal system is different here.
It's time you focused on the insurance industry.
There is, look, I think
Stop talking about games.
You know, Steve makes, I think, you know, in this debate, everybody's a little right and everybody's a little wrong.
The fact that the prosecuting attorneys very much overtried the case. They did a terrible job. And for them to get all this publicity, write books, and, you know, and all, teach in law school, I wouldn't want to be a student of those two, because frankly, they don't know how to try a case.
We're not talking about a situation where he's eavesdropping on our wives or our girlfriends, swapping sweet potato pie recipes. We're talking about a very, very real threat, an enemy that wants to kill us, and they're everywhere.
What is that got to do with going to the court after the fact?
FISA really only applies to criminal actions.
Within 72 hours,
Congress
within a week.
can't
Don't
vitiate
say
the
it only
presidential
applies to
powers.
criminal actions.
Read the act.
I read the act. There's no reason to sanctify this misconduct by the Bush administration, which is broad-based. It's not just
I think
in
Steve
this.
has said something very important, with which I
There
entirely
is
agree.
a legitimate ability to go to a court, have an independent entity look at what they're doing. Let's find out. They don't want to be in the limelight. They don't want to have people focus on their dishonesty, the corruptness, which is rife in this administration.
I think
Are they handing out money to these doctors? Because that's what you make it sound like.
No, they don't hand
Or are
it
they
out.
doing clinical studies? Are they giving out money for grants?
The doctors, look, I've seen the documents. I've done the depositions.
Okay.
I've been in the litigation. I know exactly what they do.
What do they
and
do?
what they do
What do
is
they do?
they call them rabbits. If you're a heavy prescriber, you are a rabbit, and you get lots of money. They are buying science, funding studies that have no merit whatsoever, and misleading the public, and causing women to continue to think implants may be safe when they aren't. What is it in the United States
It's not
that
true
enables
that it's in the rest of the world.
And it's almost the entire rest of the world.
Oh, it
Europe,
is
they're
not.
banned in.
It is
Even
not.
Brazil, they're banned in now. Now, the question I have for you is, why are you insisting and persisting in this when you can't even use it in Europe? These labelings, because you are engaged in a misrepresentation.
You
Do we have a
actually
lie
had a
detector
chance.
around here?
If you actually had a
not
chance
admissible anyway.
to see how cases are
Anytime you want
tried.
to, tell you what, anytime. I want to rebalance this country. I want to resurrect the real Republican Party, the one I once knew and liked. I think the time has come to really change things. Congressman Greenwood, you're a lawyer, and you know better than...
I'm not a lawyer.
I thought, well, then I apologize. That might explain why you don't know what you're talking about.
Well, that's, so I'll tell you what, Mr. Scheller.
The FDA never gets around to concluding there's fraud. It happens so seldom, you can almost never get them to act. So what happens is the consumer's stuck with going into court and having to prove fraud on the FDA, and the judge says, you can't do that in our courtroom, you got to go to the FDA, which is, as Senator Specter said, and I completely agree, a joke.
We always like to say about you, Steve, don't mince words, tell us how you really feel. But in other words, you've seen in the 20 years, and I know you've been practicing longer than that, you've actually seen, and maybe this has something to do with Don Spry talking about civility, where attorneys may not be enjoying the practice as much as they used to. Maybe they didn't get involved in practicing law, first and foremost, to be an advocate. Maybe it was something else, dollar signs, perhaps?
Yeah, I think dollar signs have a lot to do with it. Things have changed, yes, in 20 years, but what hasn't changed is my view that for lawyers, they need to practice law in a way where they really like what they're doing. And if they don't like what they're doing, then they shouldn't be practicing.
Steve was ambitious right out of the gate. The cases he took on weren't the blockbusters he would someday win national renown for, but they were often challenging and represented novel issues that he had a penchant for addressing. He took cases concerning consumer fraud, personal injury, and election law. He represented both individuals and unions, often facing off against the ingrained bureaucracy. In those years, he also undertook numerous civil rights cases with the ACLU, matters where his passion for individual rights was always on display. His political career never quite took off. Early on, he made a run for city council under the Consumer Party, but soon returned to his love of being a litigator.
During my 40-year journey, I had the opportunity to actively participate in some of the most exciting and important events in litigation of our time. Although my career has taken place through a rich network of colleagues, friends, mentors, and clergy, my passion for law evolved from first working with Professor Marvin Wolfgang, a sociology professor at the University of Pennsylvania, who was conducting a study on recidivism rates of people who had been convicted of various crimes. The study included two groups of men who were on probation and parole. One group assigned to clergy, who counseled and helped set goals for the men. The other group had no additional support beyond the normal probation or parole officer. The study was done over a 2-year period and showed significant positive results from the group that was with the clergy. And this became my first contact with the Philadelphia clergy and with Reverend Paul Washington. In fact, there was an independent review board, or I don't know if it was called that in those days, that Marvin had for the study. And the review board was composed of Jefferson Fordham, the dean of the University of Pennsylvania Law School, and Raymond Pace Alexander, and some clergy, I think Bishop DeWitt, who was the head of the Episcopal Diocese. And they were kind of watching over me at the time. And it was actually Jefferson Fordham and Raymond Pace Alexander who did suggest, they said, you need to go to law school. In fact, I don't even remember filing an application for Penn, but it was sort of like preordained, I think, by Father Washington that I was going to Penn, and Fordham knew it. That's how anyway, the 60s started off with the spirit of hope and prosperity. Great wealth and vast growth in the industrial sector of the United States gave the nation a general sense of security and prosperity. Our affluent society was setting standards for the whole world. However, With these developments, the seeds of criticism and change soon took root as many people from many different sectors of society, African Americans, women, college students, and professionals, were challenging the system based on injustice and inequality in general, as well in our schools. Much like today, problems that were occurring then, frankly, are occurring again and may be becoming even more of a problem if our budget conditions continue. It was during this time that I graduated from Penn and began to practice law. And my first involvement began, as I practiced, with what was called the Black Power movement in those days. And so you understand what was going on. There was great social strife in the community. And the civil rights and Black Power movements had officially begun. And at that time, Philadelphia's mayor was Richardson Dilworth. He resigned in 1962 to run for governor and lost. And the superintendent of schools was Mark Shedd. Well, the schools were very difficult in those times. There was tremendous, tremendous conflict, for those of you who were around to remember it. And the Black Power movement was trying to address the issues that were being presented, which, among other things, are an improved education in the Philadelphia school area, more African American teachers and courses in African American history. Ex-Mayor Dilworth and Mark Shedd, back in 1967, were negotiating with the students at that time when Mayor Tate, James Tate, was reelected mayor of the city. Mayor Tate became then appointed as his police commissioner almost immediately after the 67 victory of his, Frank Rizzo, as the police commissioner, to the consternation of the African American community and the civil rights community in Philadelphia. Kids were rioting and fighting in the schools, and the school district expelled 16 students. When they expelled the students, Congress of Racial Equality, which I was often helping because they were actually supportive of the labor movement, I was representing the labor unions, and the civil rights organizations called for a demonstration against the school board in support of the 16 expelled students. November 17, 1967, 3,500 African American students walked out of school and marched to the Board of Education at 21st and the Parkway. When the kids arrived, Rizzo was there to greet them with hundreds of cops. He's claimed to have told the cops, according to the press reports at the time, go get their black asses. I remember. The police charged, beat the students, and left 22 injured and 57 arrested. And frankly, it was a very horrifying event for me and everybody. In the meantime, the school board sought an injunction against the striking students, or the walking out students, against Gore, the NAACP, and others, and the Black Panthers, and also Bill Mathis, who was the chairman of Gore. Hearings were going on before a very, very fine judge named Alexander Barbieri, who became one of our better state Supreme Court justices eventually, and Cecil B. Moore. And again, ground zero for much of what occurred at this time was right here at Temple. Cecil B. Moore was representing Bill Mathis and Gore, and he was head of the local NAACP chapter at that time. And you got to remember the conflict and the difficulties we were in at that time. Anyway, in the atmosphere, tempers were flaring. On the 5th day of the injunction hearings, 2 attorneys, Cecil Moore and David Berger, was the city solicitor representing the Board of Education at the time, got into a shouting match. Cecil was yelling at David, and I'm quoting from the record, "You're playing footsies with racist bigots, you and the rest of the Jews. Get out of my business." I said, "Jew, get out of my business." Well, Judge Barbieri was, of course, very upset about that. He kicked Cecil out of the courtroom and was frankly going to have him suspended as a lawyer. And he looks at me, and he knew I was helping Gore at the time, and I was actually in the courtroom, and he calls me. He said, "I'm appointing you to represent Gore and Bill Mathis." And I said, "What?" Well, of course, Bill got up. I don't want a white lawyer, even though he was a friend of mine. And so the Episcopal priest, David Gracie and Paul Washington, calmed him down. And although he kept saying he doesn't want a lawyer, we calmed things down, and he ultimately agreed I could be there. And that's how it all started. And we got Dilworth and Mark Shedd. We got back into the negotiations. I calmed Judge Barbieri down. And if you look in the materials you have, you'll see a couple of letters I got at that time from some of our judiciary thanking me for that. But what would have been a much more difficult situation, and it led to very, very important changes in our schools, such as African American history, more African American teachers, and an improvement of the schools at the time. But this was going on. The Black Panthers were declaring war on the police. They proceeded to plan a People's Revolutionary Convention to be held, do you know where? Right here at Temple. And that was to be in September 1970. Well, Rizzo, needless to say, wasn't going to allow that. So he proceeded, and 1 week before that, there was a murder of a Fairmont Guard police officer and wounding of another. It was pretty rough times at the time. Nothing to do with the Panthers, but needless to say, they were suspected. And Rizzo got his police together, and hundreds of them raided 3 Black Panther headquarters in Philadelphia. In fact, by the way, Gore was based at 2229 North Broad Street. I used to spend a lot of time over there, right near your campus here. The Panthers were strip searched in front of news cameras. It was a very abusive situation. Bishop DeWitt, Paul Washington, Dave Gracie called on me to try and help out. Bail was set at $100,000 for each of these Panthers. And money, frankly, a lot of arms and guns were seized and bullets and things like that. Anyway, I showed up at the Roundhouse, got information with them, and went to Judge Reed at the time, one of our few African-American judges, with a bunch of Episcopal ministers and some other clergy, and convinced him to reduce the bail to $500. So I then returned to the Roundhouse, and you should have seen the place literally explode. Rizzo comes charging out from upstairs. He goes nuts. And the next thing I know, the magistrate, Ann Clark, who was on duty at the time, she leaves to go to dinner. And who shows up but Leo Weinrot? Now, you don't know who Leo Weinrot is, many of you, but Leo Weinrot was a 75-year-old judge who probably typifies the kind of judge you would call a bad guy. He and I get into this huge battle in the courtroom. I demand that he recuse himself, that he's biased, he had no business being there, he's a senior judge, and he would be overruling a judge who was of an equal level. He didn't care. And the Panthers were in the courtroom, handcuffed, bare feet, semi-nude, and I wanted to arrange to give him at least a blanket. He refused. So that was the battle. Now, where did it end up? Most of those, and they were kids, most of them, were found guilty of very minor offensive and many not at all disorderly conduct. But what happened, that created a terrible problem for our community because it leads us into the 70s where, again, many, many problems occurred. Now, Temple University was ground zero on many fronts. And it also leads to what was going on with labor unions at that time. The janitors and maids here at Temple, all the maids were women. There was no maid men, as they call it. Yeah, you get that. Anyway, and of course, your janitors. And they were organizing a union called the Brotherhood of University Employees, which later became affiliated with Service Employees International. And they asked me to represent them and negotiate contracts for them. So I took a look at the situation, and I saw that the maids were paid several cents an hour less than the men, the janitors, and that they were only allowed to work 36 hours a week, and the males, the janitors, 40 hours a week. And they were pretty upset about that. There was a difference, though. I tell you that. There was a difference. The maids worked harder. And what happened then, Temple Law School decided to help me in the case. And they gave me some students. And one of those students is here tonight. Sandy, Judge Sandy Moore. Stand up, Sandy. Sandy is now head of the Philadelphia Mass Tort Program and is a great, great judge. And frankly, I couldn't have done it without the kids, I call them kids, helping me at the time. They collected data, and we won the case. We got them equal pay, back pay, and all good things. And it was one of the earliest equal pay cases at that time. I don't know if you remember the history of that. Anyway, as the years progressed, and I also represented other unions and things like that, such as the social workers and the Bureau of Employment Security, and helped them organize. Andy Stern was one of my clients, and Anna Berger Price, they became the international president and international secretary-treasurer of the SEIU, the largest union in the country now. As the years progressed, I became further involved with Bill Mathis, Cecil Moore, and the African-American community. Cecil, in particular, was a champion of a wide range of causes central to the civil rights movement. And I had calmed him down. We made amends, and Judge Barbieri and Dave Berger, it all worked out, including integration of schools and trade unions, and he increased political and economic representation for poor African Americans. His aggressive manner and confrontational tactics alienated many leaders, both black and white. But in the end, there is much appreciation for him and the work he did, as noted by the renaming of Columbia Avenue to Cecil B. Moore Avenue, as well as the subway station here, and other things. Anyway, also what happened at that time, civil rights were also important to the community for mentally and physically disabled children, specifically those living in an institution known as Pennhurst, which was located in the western suburbs of Philadelphia. In 1978, following allegations of abuse and violation of patients' constitutional rights, an action was brought to close Pennhurst and distribute the children to different places and back to their families. And Judge Raymond Broderick at the time ordered it closed. There was a big problem, though. There was no plans for what would happen to these children. None. So the families, and for those judges who were here, they may remember Judge Raymond Bradley, our president judge. They called upon me to represent hundreds of families who wanted to stop the closing of the institution until such time as we created proper housing for them, care for them, and all kinds of efforts were made to try and improve their conditions. So I had to go to court on behalf of hundreds of families to the Third Circuit to reverse Judge Broderick. And thank God I reversed him, because that then led to the development of proper community housing and care for the kids. And again, we may be facing these problems again. Bring this to your attention today because the time is coming that, unfortunately, history may be repeating itself. Arrangements, as our society has grown, we have seen an exponential progress in science and technology. This progress, both a blessing and a curse, brought with it increasingly intricate cases to pursue. Gone with the simple days of the past are also the outmoded measures we used to litigate with. Highly complex issues demanded a creative and flexible mindset to engineer creative use of existing laws to address these issues. This sets the stage for some of the largest and most complex cases I've ever worked on and continue working on to this day. I'll now show you some video segments which include some of the largest cases I've worked on, including light cigarette fraud, Bush versus Gore and the butterfly ballot fiasco, and the largest pharmaceutical False Claims Act recoveries in United States history.
I was down there all week last week, and my law firm has 12 lawyers down there now counting those ballots.
The best way to count votes is by a manual count. Everybody knows that except the Republicans. These chits and all this kind of junk, that's a bunch of garbage. Secondly, if they really wanted to do it right, they would do a statistical analysis. It's been done by the top people in the United States. Stick to that. Then you have an honest vote. I tell you with absolute certainty, Vice President Gore won the election in Florida by several thousand votes if they allowed the statistical analysis or a revote. And if they don't want to do that, then Governor Bush is going to be sanctified as the President of the United States, having lost Florida if the votes were truly counted, and having lost the popular vote in the United States, and that is wrong. The sample ballot that we saw that is out there had the names all in order, 1, 2, 3, 4, 5, 6, 7, not on two sides. There was no butterfly ballot posted, and there were no punch holes posted in the sample ballot that was posted to notify the public of the ballot.
What about that, Congressman? It doesn't sound like from what he says that there really was notice.
Ahead of time. Right. People went in and walked in and punched it in various election offices ahead of the election in absentee balloting. Of course they saw it ahead of time. It was also published in the paper.
Wait a second, Congressman. No,
but who saw it
apparently it wasn't, Congressman. Congressman, there are two issues. I think what Steve, and let's get this corrected, Steve says is that the ballot that was published in the newspaper was different from what was shown at the polling booth.
Absolutely.
But what I want to make the point is...
Another big drug company. Another historic settlement.
By pushing Seroquel for unapproved purposes, AstraZeneca made patients into guinea pigs in an unsupervised drug test.
And for the third time in little over a year, the national Scheller law firm, headquartered in Philadelphia, has represented a leading whistleblower in a massive pharmaceutical fraud settlement.
So how did a boy end up taking a drug that made him grow breasts?
The New York Times has written up the whole story about millions. We're talking about large sums of money, and it's the psychiatry drugs that actually are turning out to be the #1 problem, causing diabetes, pancreatitis, boys to grow breasts. Did you know that?
When John was just 7, he began taking Risperdal for ADD. Even though the FDA approved the drug only for adult patients who are psychotic, John's doctor and others widely prescribed it to kids for less severe behavior problems. John and most of the other children weren't psychotic at all, but were given Risperdal for behavior disorders, including autism and ADD.
It's about as bad a thing as a boy can get that I can imagine.
Attorney Stephen Scheller is suing Janssen, which makes Risperdal. He claims Janssen marketed Risperdal for unapproved uses in children, downplayed serious risks like diabetes and seizures, and breast growth wasn't even mentioned under warnings, but was buried under precautions in obscure terms. Scheller represents John and 9 other boys, including this one who was only 4 when he developed a breast on one side and began producing milk.
This child has had mastectomies.
The treatment for the unbridled breast growth is as unthinkable as the disorder.
From our firm's standpoint, this is the kind of work that lawyers should be doing. Now what I want to do, if it continues, I want to see to it that the CEO of these major companies, if they do it again, this time, they will be behind bars. Your clients deceive them. And what has happened here is you've created a cigarette which no one can measure in human smokers except your companies with human mimic smoking machines. They actually have them. They know the true tar and nicotine levels.
Steve, let's go to what this is really about.
The difference is
what this
significant.
really is about.
You're really getting
the
double and triple the amount
what this is about is the plaintiffs' bar want class actions.
This is one of
they
the
want
largest
class
forms
actions. Let's
of
talk
misrepresentation
about. Let's talk
in the
about
history
what
of
this is.
country.
It's not a misrepresentation at all.
One of the things that we do know is that without these kinds of strong debates and conflict, if you call it, between attorneys, and I do get along very well with Hope Frywell. I think she's a good attorney, although I'm discouraged by the fact that too many of us on the defense side defend conduct that I consider to be unconscionable, such as the tobacco industry with their addictive cigarettes. But there's nothing I can do about that personally to change it. But I can comment about it. I can criticize people about it. I can take on my other counsel, such as Hope, and debate these issues and get the point across.
You were co-counsel in the Bush-Gore mess in Florida in 2000. I think it was Mark Aronchick, I think who was a defense counsel. You guys teamed up and actually helped Al Gore in his legal matter there in Florida.
Absolutely.
And you've also debated Bob Heim from Deckert, and you guys in some ways are best buddies until
we get along
you're here
really
on
well.
this show or in a courtroom.
That's right. And although overall, I consider Bush versus Gore perhaps my worst loss in history. Mm-hmm. And the reason I consider that is it was the result of Bush versus Gore that allowed Bush to be elected president, which resulted in our war in Iraq now, and I feel thousands of people dead and injured. And that never would have happened, in my opinion, had Gore been elected. And that's why I say I consider that loss to be devastating to me personally.
Right, although you probably were then pleased to see Obama elected in 2008. You see, Steve still got his political comment in. Here we're talking about the law here tonight. And Steve, good on you. You got that in there.
During the 1990s, I was actively involved, as you saw, in tobacco litigation, participating with a group of lawyers called the Castano Group, who were pursuing cases, including class actions, seeking recovery for states and consumers for the addiction and costs of health care related to smoking. Among our successes was receiving and getting $22 billion for the state of California. It was while litigating tobacco cases that a case in Florida was being tried in which David Townsend, the research director of R.J. Reynolds, who was the defendant in the case, put into evidence charts showing that the average smoker takes in 500 to 600 milliliters of smoke from each cigarette smoked. Immediately, I sensed something was strange, because the FTC Cambridge filter test, which was used to measure tar and nicotine levels, produced only 300 to 350 milliliters of smoke. If this was true, it meant to me that tar and nicotine levels have never been reduced by anything close to the 50% claim made by the industry in the past 35 to 50 years. Later that year, I was in Winston-Salem, and this is 1997, to depose Alan Rodgman, the retired research director of R.J. Reynolds in our Castano litigation. He was being paid $3,000 per month as a consultant for Reynolds in addition to his retirement pension. I subpoenaed him one late night to make sure I got him at home and to produce any documents he had. And lo and behold, he had a bunch. And after a battle in court, a court order, he had to bring 9 boxes of documents to the deposition, which was held August 5th, 1997. I insisted on delaying the start of the deposition while I and some associates went through the boxes. And we found a report he had prepared for Reynolds in 1994 while in retirement, which was never published or disclosed, except to some Reynolds officials who ignored it, outlining the entire light cigarette fraud. The lengthy report outlined how the cigarette design enabled the deception that they were lower in tar and nicotine than regular cigarettes and better for your health. It blatantly stated, he stated in the report, that's what the report said, the smoker was more likely to be deceived by these cigarettes and that the chemicals in these cigarettes were actually more dangerous than the tar and nicotine from regular cigarettes. It was in this report. Borrowing from my class action experience, I developed a strategy to pursue class actions pursuant to state consumer protection statutes for fraud and recover the money for all the smokers had paid for cigarettes such as Marlboro Lights, and sought an injunction to prohibit using words such as light, lower in tar on the packs of advertising. Look around you today. Those words no longer exist on cigarette packs. Just this past February, in the AA, American Association of Justice annual winter meeting, I was awarded their inaugural Pioneer Award by the Tobacco Control Resource Center based at Northeastern University Law School for the discovery of these key documents and the use of this successful strategy. In fact, the federal government took up my strategy, sued the tobacco industry in Washington, D.C., and based on my theory of light cigarette fraud, Judge Gladys Kessler wrote an astounding 1,742-page opinion in August 2006. And after years of appeals, the industry is now facing severe penalties, which they're fighting with her now about, and has been ordered to permanently remove any hint of this claim, and she is requiring them to affirmatively state that light cigarettes were fraudulently represented. Court actions today are ongoing that I'm heavily involved with. We have certified class actions in Massachusetts, Minnesota, Missouri, and also partially some in California, and even in British Columbia, where I was brought in as counsel and have a certified class, although I wish they had wigs there. We also obtained a $10 billion verdict in Illinois pursuant to this strategy that was reversed by one vote in the Supreme Court of Illinois. But fortunately, by sheer happenstance and good luck and good litigating, this verdict, believe it or not, may be resurrected. I can't discuss all the details now. It's too complex, but there are things happening that will be very surprising. Judge Kessler also aimed her wrath at the lawyers who represented the industry, highlighting 3 firms as especially loathed: Covington and Burling, Jacob, Menninger and Finnegan, and Shook, Hardy and Bacon. Now we get to Bush versus Gore, which was ongoing as I was working on the tobacco litigation. At the same time, Bush was running for president against Gore. On Election Day, I received a call from my mother-in-law in Boca Raton, who was absolutely apoplectic because she believed that the ballot design may have caused her and many others in Palm Beach County to vote for Buchanan instead of Gore. In fact, my father-in-law is here today, and he was really upset too, but he still says he voted for Gore. So I called Ed Rendell, who was the head of the Democratic National Committee at the time and a friend of mine, and of course by the next day realized the problem created by what became known as the butterfly ballot. Gore wasn't ready to pursue any claims, and Secretary of State Catherine and the board in Palm Beach County was about to certify the Palm Beach results in favor of Bush. I called 2 lawyer friends of mine in Florida, Gary Farmer and Dave Crathan. Dave is now a Broward County judge. And we filed, at my suggestion and work, we filed a class action complaint to obtain a preliminary injunction to stop them from certifying the Palm Beach County results, and also to either award the election to Gore on my statistical kind of analysis, and order, or at least order that the recount go forward. And Catherine Harris had already ordered the recount to be stopped. So you got to understand the posture. The hearing was scheduled 10 days later. I had the injunction in hand to determine whether the injunction would continue. And I hold the all-time record in Palm Beach County for judge recusals. By the way, they also called me a carpetbagger. I think it was 6 or 7 judges would come out, every one of them recuse. I said, what's going on here? Maybe they don't like me. Anyway, so what happens is we finally get a Republican judge, George LaBarga, who happens to be a nice guy, but he was head of the Palm Beach County Republican Club before he became a judge, so you know where he is. But he was very fair, actually. I was surprised. Anyway, one day, we arrive at the courthouse for the hearing, and we're standing at the door waiting for it to open, and it was locked at the courthouse. And they have a beautiful courthouse in Palm Beach County, state courthouse, not federal. The police were in front of us, it seemed like dozens and dozens, maybe more, dressed in full riot gear with helmets and clubs, and here we were in our suits. Coming from one direction was Jesse Jackson and hundreds of people supporting getting the election recount. Coming from the other side were Bush supporters, who I refer to sometimes as rednecks, but forgive me, and hundreds of them. And we're in the middle. And we were banging on the doors. In the meantime, I had called Mark Aronchik from Philly, from Hangley, who was an expert. I said, you got to get down here and help us. So he came down. He's there with me. We're waiting to get in the courthouse. Finally, thank God, the doors opened. There were dozens of helicopters above us. And I don't know what would have happened to us if we were still... Anyway, it was quite an event. And as a twist of fate, I realized that Bush was being represented by the law firm of Greenberg Trauig, which my first cousin, Larry Hoffman, was the founder of and managing partner of at the time. So this was truly a family battle. Can you believe that? And Larry's a good Democrat. Don't tell Bush. I believe I hold, as I said, the record for recusals. What we ended up with the judge refusing to continue the injunction, but a major victory, which is not talked about in the movie, our involvement, there was a movie. The victory was the recount was ordered to go forward. And that's when Gore enters the proceedings, and starts getting David Boies involved and some of these name brand lawyers. And I was, frankly, I had asked them to consider asking for a total recount in Florida because I was concerned with the implications of not doing that. No one listened to me on that issue. But anyway, the U.S. Supreme Court, with its final ruling on Bush versus Gore, stopped the recount, which had the effect of awarding Bush the majority of votes in the Electoral College and the presidency. That's why I feel this was a terrible loss. But a lot of people don't know that history. Anyway, we got into pharmaceuticals. And let me tell you an aside. There is an issue as to whether those ballots were fraudulent. They were manufactured in Addison, Texas, Bush's home state, of course, by a company that was a known Republican-supporting company. And although it's never been disclosed before, there was photoelectron microscopy done on our behalf at Cambridge University. We were never able to prove it, but our suspicions were partially confirmed. If we had enough ballots to prove it, those ballots had been manufactured to create the Buchanan hole falling out easier than any of the others. Can't prove it, so don't accuse me of saying it happened. It never went further. I've always had this suspicion. Beginning in the 90s, the drug industry was developing two new classes of drugs. The first, known as SSRIs, are drugs that are known such as Prozac and Paxil. And the second generation of antipsychotics, such as Zyprexa and Seroquel, were touted as safer and more effective than the first generation of similar drugs, such as Haldol. As I said, when the Dodgers left, thank God they didn't have those drugs there. In our drug and medical device industry, we have immense greed, denying us truthful, accurate information about the adverse effects and dangers of these drugs, particularly the SSRIs and antipsychotics. In addition, we have a weak and understaffed FDA that often adds to the danger consumers face. Frankly, the best thing they could do, the drug industry, is develop a drug that diminishes their own greed impulses. Anyway, Lilly's patent for Prozac was about to expire, so they created an extended release Prozac version and somehow got a patent for it. To me, there's nothing unusual about putting something around it and let it dribble out over a period of time, but God knows why these patents get issued. Now they needed to move the doctors and patients to the much more expensive and non-generic form of Prozac to continue their huge profits. Believe it or not, the Lilly detail reps in Florida went into doctors' offices, got the names and addresses of any patients who had ever been on an SSRI, arranged to have the doctors, remember the rabbits I was talking about? Arranged to have the doctors sign prescriptions for Prozac, unknown that the patients had no knowledge they were going to get them, and then hired Walgreens and paid them to fill and mail the scripts, the prescription drugs, not the script, the drugs, as a gift to the patients. Believe it or not, that happened in Florida. Gary Farmer calls me up and he says, "You won't believe this." I said, "I don't believe it." Anyway, well, what did we do? We filed a class action against Lilly. We sought to have the doctors disciplined, and they got a little slap on the wrist, but those doctors, it's a shame what those doctors get away with. The attorney I was working with, and he turned to me and we began the class action. This suit led to my appearance on national television discussing these issues with one of the clients who had gotten these drugs. And then I get a call from Lilly reps, 6 of them, in California and Oregon, and they said the same thing was going on there. And I started to question them and learned about illegal marketing of a drug called Zyprexa. Now, this is 2001. I knew something about the False Claims Act, but the False Claims Act had hardly ever been used up to that time. You may not realize it, but it had been on the books from the Civil War and amended in 1986. And I said, this sounds like a key tam case. And everybody said, what do you mean key tam? Anyway, I said whistleblower. So I filed the first whistleblower case against Eli Lilly. And a few months later, I asked Mike Mustikoff to join the team with Duane Morris and Gary Farmer. And of course, I always say, had my mother-in-law not called me during Bush versus Gore situation, I never would have gotten to handle this case in Palm Beach County and involving the drugs. So I thank my mother-in-law for getting me perhaps the biggest case I had ever been involved with up to that date. And what happened was the case was under seal, believe it or not, for almost, it started in 1972, was being investigated, and we were pushing the U.S. attorney, and I can be a pain in the butt. And the end result was finally, in the year 2000, late 2008, a handshake settlement was reached with the government for $1,420 million, and a guilty plea on a misdemeanor by one of the Lilly divisions. And on January 31st, 2009, the guilty plea was entered, and the public learned about that case formally. That same case, one of the detail reps was fired by Lilly for complaining about this behavior. And he, luckily, because the case was under seal, was able, and if it had been known about him, he never would have gotten this job. He gets a new job with AstraZeneca to sell, guess what? Seroquel. So, 2004, we filed the Seroquel case, key tam, and lo and behold, April of this past year, $520 million were paid to the U.S. government. And again, I thank my mother-in-law. The Pfizer case I had, it didn't come from my mother-in-law, but that case I had one of the major drugs, and that resulted again in a misdemeanor conviction for one of the Pfizer subsidiaries and a payment to the U.S. government of $2.3 billion. So these, and I can tell you right now, my days are not over. I have several under seal. You will see some things happening in the future, I hope, that will hopefully beat these cases. But right now, I had the largest award settlement in the state of Pennsylvania in 2010, the largest awards ever in the drug pharmaceutical industry. And the moral of the story is that my entire career practicing drug law has been focused on injustice, the injustice of discrimination against people, black or white or men or women, the injustice of putting severely disabled children in the streets, the injustice of dumping toxic chemicals on historic lands and polluting our earth, the injustice of consumer fraud. It didn't matter what the case was or how difficult it would be, whether it was representing our vulnerable population or trying to stop a tampered election. I followed my inner conscience, and it led to good things, not only for the people that I represented, but for me personally. I would like to impress upon you today that you have a tremendous opportunity, particularly the students, to right the wrong, as there is great injustice going on right now in our country and in the world. We are facing perhaps one of our worst financial crises since the Great Depression of the 30s, because of financial failure to regulate, predatory lending, and staggering greed. In Wisconsin, we have the denial of collective bargaining rights for unions that were hard fought and won in the past. These crises are a catalyst for positive change. Do not be afraid of them. Do not ignore them. Embrace them. Find your inner conscience and follow it, not the lure of easy money. And this will bring the greatest rewards of all. And I quote again from Justice Sotomayor, who spoke at the Bar Association last week, Philly Bar. The best advocates are those who do not merely advocate on behalf of their clients' interests, but address the development of American law in the best interests of our people. The worst are those who do not respect the law. I would like to finish by thanking you for taking the time from your busy day to join me here tonight. My hope was to inspire law students as they begin their journey and to honor all those that have gone before us that have contributed invaluably to the shaping of Philadelphia as well as the nation. There are handouts available that include documentation from the cases I mentioned here tonight. I hope you read through them. They're very interesting. Feel free to contact me if I can help you in any way, or you would like to discuss these cases further. The last video I will show tonight is with former Edward Rendell. And although Ed is addressing me, I would like to think he could be addressing any of the aspiring attorneys tonight.
I wanted to take this opportunity to thank Steve for what he does in the public sector. Of course, first and foremost, he's a great lawyer, he's a great family person, he runs a terrific business, all of those things. But Steve loves politics, loves government, understands that with all its warts, it's the only way to get things done, to make real change happen in this country. But he just doesn't pontificate, he just doesn't sound off about what needs to be done. He puts his money where his mouth is, and he puts his energy and his work product where his mouth is. Steve has been a great contributor to so many good causes, mostly good Democrats running for office locally, regionally, or nationally. But he's also been a tremendous help to us in our election efforts. When there's an election question, or when there's potential voter suppression, or when there are recount problems, the first advice I give to Democrats all over the state is call Steve Schaller. Steve gets on these cases like a laser, locks in, and finds usually a way to make sure that fairness triumphs. In fact, I tried to get Steve involved in Florida and in Ohio in 2004, and if the powers that be had taken Steve on as one of their primary advisors, I'm not so sure that we would have suffered through 8 years of the Bush administration. Am I right, Steve? But in any event, Steve, thanks for all you do for so many of us, myself included. Thanks for what you do to try to change public policy and change it to protect ordinary working people, to help the most vulnerable people in our society. You don't have to do it, but you do it because you care.
And where that future goes is very unclear. But I think one thing is clear, that the lawyers need to focus on doing what they consider to be in the best interests of not just the client, but in terms of what's in the best interest of preserving our country and our Constitution and the rights that we are so dedicated to for these over 200 years. And I think if we do that, things will shake out in the end. The lawyers will be successful. They may change the ways they do things. They may take less money and by the hour. They may handle different kinds of cases. But that is so critical, to do something that you love to do and to do it correctly, focus, and make sure it's the right thing that you're doing.